Mr. Salton. You may proceed.
Madam Chief Justice, and may it please the Court, this is Defendant Thomas Crouse's direct appeal from his conviction for first-degree murder and arson of a dwelling. The overriding issue at trial was the identity of the perpetrator. The Commonwealth's case against Crouse consisted of circumstantial evidence along with the testimony of an experienced jailhouse informant that Crouse had confessed to him. The case was submitted to the jury on three theories of first-degree murder: deliberate premeditation, extreme atrocity, and first-degree felony murder, the underlying felony being aggravated rape of a child. And the jury convicted on the first two of those theories. There are a number of issues raised in the brief, and unless the Court points me in a different direction, I want to focus on three of them in the limited time I have. First, on the trial judge's limitations on cross-examination, which prevented defense counsel from demonstrating to the jury that the jailhouse informant in Tonti was fabricating his testimony. Secondly, a plethora of bad acts, testimony, and physical evidence introduced over objection, which portrayed Crouse as a convicted felon, a drug user, and a philanderer. And finally, the trial judge's denial of the defendant's motion in limine to exclude his prior conviction for aggravated rape to impeach him if he took the stand at trial.
In your brief, you made, I thought, a very persuasive argument about why being able to cross-examine, was it the police officer about the blue fabric?
Lieutenant Connolly, Your Honor, yes.
Was important to impeach the credibility of the informant. I thought you were very persuasive in that regard. But trial counsel wasn't very persuasive when it was asked to explain what's the purpose of this. And doesn't the judge have to rule based on what trial counsel has represented as the purpose?
Of course he does, he does, Your Honor. But I think the trial counsel really did. If you look at the actual sidebar colloquy, which is at begins at page 216 of our appendix, I mean, just to set the stage, Intanti and Crouse were together in the Middlesex County Jail between February 7th and April 16th of 2002. That was the time period that overlapped. And Intanti testified that at some point Crouse learned that the Commonwealth investigators had discovered a blue fiber and that Crouse, quote, went bananas and was so upset that he stayed in his cell for 4 days. That was the gist of what Intanti had said. And what defense counsel was attempting to demonstrate was that, in fact, the defense had not been apprised of that fact, that is, the discovery of a blue fiber by the Commonwealth, until April 26th, 10 days after Intanti lost contact with Crouse, so that there was really no way that Intanti could have possibly been telling the truth when he said he got that information from Crouse.
Now, and that's the argument you make in your brief.
Well,
very
Your Honor,
persuasively.
but to be fair, when defense counsel at trial asked the question of Connolly, wasn't the blue fiber, was it the April 26th, asking about the April 26th discovery, was that where the blue fiber was disclosed? And the Commonwealth objects, saying, we object, that's afterwards. They go to the sidebar, and the court says, reading from the 216 of the appendix, the court, isn't this after, meaning after Intanti and Crouse had split up? And defense counsel says, it certainly is. How would Intanti know about a blue fiber? I went through my entire file. This is the first time I found anything regarding a blue fiber, meaning April 26th, and it's after he left Billerica, and I'm just perplexed by the whole thing. And then Bakari goes on, defense counsel, the inference is, I think, Intanti somehow had information on this before I did. I went through the file. And then Bakari says, I have nothing to show about a blue fiber before he left. Bakari, how would he know about a blue fiber? And Bakari said, finally, he gets to the point. He said, Intanti had prior knowledge somehow. In other words, Bakari is exactly tuned in on the issue here, which is Intanti somehow...
He's saying that Intanti must have had knowledge prior to April 16th.
Well, Your Honor, he's saying
about this.
Yes, he's saying Intanti had to have knowledge from a source other than Crouse. And in fact, the prosecutor gets the point, because the prosecutor says that I certainly don't think there's any evidence whatsoever that I was providing discovery to Mr. Intanti before I was providing it to counsel. So everybody gets the point. The point is that Intanti must have had a different source for this information other than Mr. Crouse. If he's being fed information from somewhere about something as specific as this, who knows how much of the remaining details of this supposed confession had been fed to him by somebody else, not, in fact, admitted by Mr. Crouse. Bakari, I mean, this happens in the middle of a trial. He doesn't know what the source is of that information, but he has a right to demonstrate to the jury the problem. And I think he did sufficiently alert the court to exactly what the problem was, and the court ultimately sustained the Commonwealth's objection and did not allow him to go into that. So the jury basically never heard about that difference. Now, you can say, well, this is just a little small thing. It's a blue fiber. It's 10 days. But it's a big thing when you're talking about trying to impeach a jailhouse informant. This is very – when somebody testifies at trial, I was housed with the defendant in jail, and he basically confessed, and here's what he told me. It is difficult to disprove that. You're trying to sort of prove that that didn't happen. And the only way to do it, if you're a trial counsel, is to focus on something like this. If the informant is making the stuff up and he slips up,
well,
like he did here.
If he's not making the stuff up, but he's in fact been given information by somebody other – I don't care who it is.
Right.
It needn't be the Commonwealth. It could be anybody, correct? It's not Crouse.
Correct. That's what's important.
Right? So we really don't have to figure out whether the prosecutor, and I can understand if I were the prosecutor saying, come.
I didn't give it to him.
No, I mean, the prosecutor has a very good reputation to protect. I mean, I'm going to make it clear and make a representation to the court that didn't happen.
Correct.
That did not happen. And the court accepts that. And as far as I can figure out, defense counsel accepts that, too.
Well, the court accepts the representation, but that should not be the end of the story.
No, I understand that.
Right.
I understand that.
The jury, in assessing credibility, should have that presented to them very squarely, so they can be asking themselves, well, how did this guy know about something that the defendant didn't know about till after April 26th, when they split up on April 16th? He must not have been getting all this stuff from Crouse. I mean, it's something which clearly cast doubt.
What did the trial judge do in response to all of this?
He simply sustained the Commonwealth's objection and did not allow defense counsel to pursue that line of inquiry.
Did he explain why he had done that?
No, Your Honor. He just sustained the objection, and defense counsel moved on. I mean, to me, the analogy I thought of is if there was a search conducted on April 16th, and the issue was did the Commonwealth have probable cause to conduct a search, and the defense could show that some of the information that the Commonwealth was supposedly relying upon in its April 16th search was not, in fact, available to the Commonwealth until April 26th, that would be, it seems to me, highly probative of whether or not there was probable cause on April 16th. And yet, in this case, the jury was deprived of that information and really deprived of a fair opportunity to assess Intanti's credibility. And that's really and in this case, where you had, I submit, certainly not an overwhelming case by any means. They had a videotape, which I submit is equivocal, showing Crouse at the gas station shortly before the fire.
The videotape was in evidence, correct?
Yes, Your Honor, and we've asked that it be submitted to this court for this court.
Well, we look at all the exhibits in Murder One cases, so that'll come.
Okay.
Well, they also had her body, didn't they?
Yes, Your Honor, and there was nothing on her body linking her to the defendant.
But the location?
Well, the location was in southern New Hampshire. The defendant did drive with his girlfriend, Diane Bussiere, and their two children to southern New Hampshire that morning. That's correct. The testimony at trial was that had been planned the previous day by Ms. Bussiere. There was testimony about what they did when they got there, the sequence of events. So, yes, they're in the same state. That's true. The body is found in southern New Hampshire, and the defendant is in southern New Hampshire. That's relevant, but I don't think that's particularly compelling as far as evidence of his guilt.
So I'll ask the Commonwealth, but what was the theory that he put the body in the car with the kids and drove it up to New Hampshire?
I guess that's their theory, Your Honor. That's right. that the whole family and the body went up to New Hampshire together that morning.
You argue that it was error to admit the testimony about the dog alerting to gasoline.
Yes, Your
Yeah.
Honor.
Now, if it were, how would that be harmful to the defendant when there is that video that shows him the inferences putting gasoline into the hatch? And also, why would he go to a mobile station rather than his stepfather's place to get gas? And why would he get only $5 worth of gas when he's going to drive to New Hampshire? If
Your
he's
Honor,
putting gas in the trunk. I mean, gas in the gas line.
I think those are all fair questions. Number one, I believe the testimony was he did not have access to the gas pumps across the street at the business that his stepfather ran. Number two,
Is that in evidence
I
that he
believe
didn't
it
have
is, Your Honor.
access?
Yes. And there was, if you look at the videotape, it is not clear from the videotape that he is putting
I understand
gas.
that's your argument.
So
I
therefore,
understand that.
essentially the importance of the positive alert by the dog, which was then unconfirmed in the laboratory, is that in fact there was gas in that part of the vehicle. It's not incredibly overwhelmingly important evidence, but it fit in with the Commonwealth theory of the case, and that's why they put it in,
Right.
and that's why the defendant wanted to keep it out. It was part of their theory of the case.
Yeah, but I'm also asking, why would he put $5 worth of gas in the car when he's about to take a drive to New Hampshire?
Well, Your Honor, maybe his gas tank was already three-quarters full. I have no idea.
From going from where he lived to New Hampshire, you can do it on three-quarters of a tank of gas.
Well,
That's
it's
common
only,
knowledge.
the testimony, Your Honor, was that it took less than an hour to get there. So
Right, so you can do it on, you don't need to top off your tank.
Well, that's
in
true, Your
order to
Honor, but
get there.
if you're filling, there was testimony that one of the things he did in New Hampshire was he unloaded a gas-powered weed whacker that was being used was sold at a garage sale up there. Maybe he was filling up the weed whacker. I don't know.
Maybe, so, but if maybe he's filling up the weed whacker, you're conceding that maybe he's putting the gas hose into the back
Of course, Your Honor,
of the
that's a
car,
possibility.
not into the gas
Of
tank.
course, based on the circumstantial evidence, the jury certainly could have found that. I'm not arguing it was insufficient evidence to convict. I'm arguing that
No, but I'm saying, why was it harmful? I have a hard time seeing that error, if it were error, that it would be harmful.
I think it was harmful only, Your Honor, and that it fit in with the Commonwealth theory of the case. I don't think it was a particularly important piece of evidence, and that's why I didn't plan on arguing it today. I do think what was important, so Intante was a critical witness because the rest of the case was not that strong. But in order to improve this case, what the Commonwealth did is they got into evidence over objection, testimony that Crouse was a convicted felon, which was totally irrelevant. It should not have been in the case. Secondly, they got testimony from three witnesses that he either was interested in using or providing drugs to others, which also, the problem, Your Honor, is that the Commonwealth had a theory. Their theory was Crouse used drugs to lure the victim to this basement function room where he raped and killed her. That was their theory. The problem was there was no evidence that supported that theory. So to make up for the lack of evidence, they get into evidence that on some occasions he has used or offered drugs to others. They get in evidence that on some occasions he's expressed an interest in other women. And they get in evidence that there is found in the function room a woman's bathing suit bottom, which is not tied to the victim in any way, and a bag of what looks like cocaine but what turns out to be sugar, which is not tied to Crouse in any way. And they throw all of that in because, basically, to suggest to the jury, our theory is right.
Don't they also get in evidence that he made the statement that on occasion he used the function room to party?
He did make that. He did make that statement, Your Honor, according to testimony.
So you're not objecting to that?
I think that is at least closer.
Yeah,
okay,
certainly.
But just general testimony, because then what happens when then they're able in their closing argument, the prosecutor says, we know that when Mr. Crouse parties with girls and broads, to use the language of the prosecutor, quoting a witness, he likes to use cocaine. So, in other words, that's their theory, and they get the elements to support their theory, but none of it is tied to this case. It's essentially propensity evidence. It's exactly why we're supposed to keep out that kind of evidence, because the jury should be deciding guilt or innocence based on testimony about this case, not some generalized testimony about the defendant's character. Particularly, why is the fact that he's a felon relevant? other than to, again, demonstrate that he's a bad person who uses drugs and chases women. That essentially was their theory of the case, and they wanted the jury to make the speculative leap like, oh, well, that must be what happened in this case. That's not how convictions for first-degree murder should occur, and the only thing they had other than that was basically in tanti to tie the whole case up into a nice little bow. Now, the third issue I want to focus on is this issue with the prior conviction.
The loose issue?
I'm sorry, Your Honor?
The loose issue?
The loose issue, yes, Your Honor.
On that question, on that issue, I'd just like to ask you a question. The Commonwealth argues that much of your argument here is based on sheer speculation, and one in particular stands out to me. How can we assume that the defendant would be better off if he testified? I mean, we've seen transcripts all the time when the defendants are really harmed by testifying because it gives the government an opportunity to show all the inconsistencies in their story, and there were plenty of inconsistencies here.
Well,
They could have been worked through to the Commonwealth's advantage if the defendant testified.
I suppose, Your Honor, it's conceivable to talk about a case where a defendant's denial of his right to testify in his own defense could be deemed harmless error, but I really don't think so. I think that a defendant has a constitutional right, number one, to testify in his own defense, and that shouldn't be unconstitutionally burdened. Secondly, there are numerous cases, including this case.
But the admission of prior convictions is not a constitutional question, either state or federal.
Well, if it has...
I mean, it may have. It obviously will influence decisions about testimony or strategy, but it doesn't. It's not unconstitutional.
Well, certainly the United States Supreme Court has not so held. It seems to me that certainly that it's, and this court has not so held. But it seems to me that when you're talking about, and let me first answer Justice Cowan's question. There are numerous cases. This court's case in Commonwealth versus Duran, the First Circuit's case in Uber versus Garino, a case we cite in our brief. I think it's called Hunt. There are many cases where courts say, look, there's nothing to substitute for a defendant's taking the stand and basically addressing the jury and denying guilt. There's nothing that really substitutes for that. In this case, as we point out in our reply brief, there were a number of issues that were raised that only Crouse could testify about. That's why in the motion in limine, Crouse's lawyer said this is a case he has to testify in. But because the judge said that the Commonwealth could use a prior aggravated rape conviction in a case where he's charged with the underlying felony of aggravated rape of a child, I mean, no defense lawyer in their right mind could put a defendant on the stand in those circumstances. There's no limiting instruction that could be given that would enable a jury to somehow take that piece of information and bury it into that little corner called credibility and ignore it with respect to whether or not the defendant did the crime. That's what this court, I think, has suggested in a line of cases, Fano and Andrews and Leftwich, saying, look, we are concerned, particularly concerned where there's a similarity, a close fit between the prior conviction and the case, the charge that's on trial.
Well, shouldn't we at least require that the objection be made again at trial, in the course of trial, when it's quite clear what the evidence is, and the judge can then make a better balancing test? I mean, shouldn't we at least require that?
Well, I think, frankly, Your Honor, I think that the judge should not make a definitive ruling. In other words, I think that what's more appropriate is for the judge to say, look, right now, I think I'm probably going to let this in, but I'm prepared to revisit it. So before
that's what he said. That's what the judge said.
No, he didn't say that, Your Honor.
And then I thought he did, and then he just allowed the motion.
Well, he did say that, and then he indicated he was still thinking about it, but then he endorsed the motion that the motion was denied. It was not. He didn't suggest it was preliminary. He didn't write anything saying you can ask for reconsideration. So yes, I think that in abundance of caution, a careful defense lawyer would have before resting, gone to sidebar and say, Judge, please, one more time, let me beseech you, don't, to reverse your prior decision, reconsider it, don't let that conviction in. But I don't think that's a requirement. It certainly was not a requirement at the time of this trial, and I don't think defense counsel should be faulted. And more importantly, I don't think the defendant should be deprived of relief because his lawyer didn't do that. I think that is something the court can certainly consider requiring as a procedural step in order to preserve the issue. But I don't think that what the Commonwealth's asked for should be adopted, which is this test that says that in order to raise this issue on appeal, you basically have to commit legal suicide at trial, get yourself convicted, and only then can you raise the issue on appeal. I think that basically the effect of imposing that rule will be to insulate these kinds of decisions on appeal because the defendants won't testify, and therefore the issues never will be raised, and this kind of unfairness will be perpetuated. And I ask the Court to reject the Commonwealth's suggestion that it adopt the loose rule. Thank you, Your Honor.
Thank you. Ms. Grant?
Good morning, Your Honors. My name is Marguerite Grant. I'm an Assistant District Attorney in Middlesex County, and with me today is Adrian Lynch, also an Assistant District Attorney in Middlesex County, who was the trial prosecutor. The Court should take this opportunity to follow loose.
Why should we do that? I mean, we have our own unique rule that every aspect of a case like this is examined for a substantial likelihood of a miscarriage of justice. A lot of these other states, or probably most of them, all of them, don't have such a rule. So why do we need to bother with loose? If in fact whatever occurs in a situation like this is so bad that we think the defendant might have been improperly convicted, we'll take care of it under 33E. Have you thought about that?
I haven't thought about it in the 33E contest,
But
it
what makes the whole point. Because
We don't need the rule, is the point.
Well, except it's back to Justice Cordy's point, that at the very least, the defendant should be required to renew the issue at trial. As
that's
Chief-
different.
Well,
Let's leave that
that's
aside.
true.
Loose is not. That's not loose. Loose essentially says, if you don't testify, I don't know if they use the waiver language, but I mean essentially you can't raise it, and that in the context of forget 33E. Mr. Sultan's last point was, we're never going to look at the trial judge's ruling, because if the defendant, you and I know that whether you call it legal suicide, those are very, very fine calls, and if the trial judge is going to let it in and say you can't challenge that unless you testify.
But the judge's ruling, quote unquote, is an in limine ruling, and this Court has held many times in cases like Welton that a ruling on a motion in limine is a preliminary ruling at the threshold.
No, I understand that, but Luce is not dealing with that. Luce is dealing with Luce is assuming that the issue has been properly preserved, for whatever issues you want to raise on appeal.
And I'm saying it wasn't here.
Oh, no, I understand that, but that's not Justice Graney's question. You're saying, you started off by saying this Court should take the opportunity to follow Luce.
Right.
Okay. You've just told me the question wasn't properly presented, it's waived, therefore you shouldn't rule on the question of Luce.
Well,
You can't have it both ways.
I think I can.
Why? Well, then don't address the it was waived. Now assume that I've said to you it's not waived. Now tell me why I should adopt Luce. Because if it's waived, then I've got 33E, but that's not because I'm considering the issue. That's something different.
It was over 19 years ago that that Justice Abrams wrote in Fano that will assume without deciding that the defendant can raise this on appeal. The Court repeated that twice more in Ferroli and Cordero.
Right.
I read that as this Court having flagged the issue for future consideration, as it often did in those days, sometimes postponing reaching an issue that might be novel, waiting for cases to come down. Since then, we now know what almost every other state does in whether or not to follow Luce.
Yeah, but do they have 33E review?
No, they don't have 33E, and they also have different statutes, different from Chapter 233, Section 21 on...
So could
And
you-
this rule would apply to more than just murder cases. It would apply,
That's
of course,
correct.
to...
So the 33, that's one reason to think about it, that 33E won't be there in these other kinds of cases. And we now know what other states do. We have examples of cases like Commonwealth v. Bly, where the prior conviction was for a first-degree murder, and the defense actually used it to the defendant's advantage in that case. The court had it attempted in Fano to just craft a decision, wouldn't have had the benefit of seeing fact scenarios like that unfold, where there may be circumstances where a prior conviction comes in that an appellate court can't imagine just on a hypothetical question. But in any event, this, I think, based on the fact that what other states do, the amount of time that's passed, and the fact that this issue has been flagged, as the Supreme Court of Rhode Island did, just since I filed my brief.
I saw you filed a post-brief
Yes, I filed a
letter.
16L letter. They, after giving it full consideration, they very carefully thought about it and ruled that they were going to follow Luce. They're not bound by the federal rules of evidence.
No, we're not talking about federal rules of evidence.
But based on the logic of Luce, on the fact that without the defendant actually testifying, it's impossible for an appellate court to review the ruling for prejudice to the defendant or for harmless error. You can't tell. Maybe you would have done something like what Jeffrey Bly did and said, come up with some theory as to why the prior conviction was actually, in some theory, exculpatory. So I would ask this Court to follow Luce. But in any event, here, where the defendant didn't renew the motion at trial, and furthermore, he never filed a motion for new trial. So we can't just assume that this defendant was chilled from testifying because of his prior convictions. The ruling to admit the prior convictions in limine was made on September 4th of 2002. It was 3 weeks later to the day that the defense rested without calling the defendant.
Ms. Grant, I didn't understand your saying in your brief that the judge might have changed his ruling about the admissibility of the prior convictions after he heard Antanti's testimony. Why do you say that?
Because Antanti's testimony, and I won't repeat it, was particularly graphic and crude. And it was undoubtedly very compelling for the jury to hear what Antanti said this defendant did to this 14-year-old girl in that function room and how he bragged about it in jail afterwards. And so the judge, Feroli says that we have to consider what the judge knew at the time he made the ruling. There had been this wonderful intellectual discourse before trial between the trial prosecutor and the trial defense lawyer and the judge in the judge's attempt to rule on the motion in limine. And the judge kept saying, I know the cases say I'm supposed to make a ruling, and in contrast to what defense counsel has just said, the judge is supposed to give the defense a benefit of a ruling before trial. And the judge repeatedly said, I want to make it clear, I understand, I have discretion, and I'm exercising that discretion, and the Supreme Judicial Court has said they want to hear these magic words, is what he said. So in any event...
Oh, that's another answer to the issue. We've never really reversed anybody who's used that test.
That's
even when the crimes in question have been substantially similar to the crimes that are being tried.
And that's Commonwealth v. Reed, Your Honor.
Okay, but you still haven't answered my question. I've heard a lot of talk, but what is the answer to the question? Why do you say he might have changed his mind?
Because of the graphic nature of Antanti's testimony, having seen...
But why? So
having seen the Commonwealth's case go in...
Might have changed his mind to say you can't use the convictions?
Possibly.
Why? Because the case was so strong? Is that what you're saying?
Could have
Or
been.
because it's so close, correct?
Yeah, because
for any number of reasons.
I mean, one of the convictions was rape. Another one was assault with a knife. A knife was used here. I mean, I'm agreeing with you. He might have changed his mind.
Just to be clear, he was very careful about making sure to ask the Flabat question in the pretrial voir dire of jurors. And there's a misstatement in my brief. I refer to the prior convictions as rapes, plural. In fact, the prior conviction was for assault with intent to rape and assault and battery dangerous weapon. And the uncharged predicate felony here was attempted forcible rape of a child.
Yeah, you argue in your brief that the defense counsel didn't argue that the rape conviction shouldn't be admissible, but in the supplemental brief, the gray brief at pages 17 to 18, Mr. Sultan indicates and quotes some language indicating that the defense did argue that the rape conviction shouldn't be admissible.
The focus of the defense counsel's pretrial argument was on the...
Well, it doesn't have to be focused as long as he argues it, as long as he gets it out there so the judge knows it. And he quotes, he says that defense counsel referred repeatedly to his conviction for aggravated rape, noting that the aggravation was that the rape was accomplished by means of a knife, and he argued that with that degree of similarity in crimes, we also have just enormous spillover that would be engendered, if not completely poisoned, this case, if that conviction is either brought in if Crouse testifies. Now, that seems to me that's argued.
Right. Well, see, what happens is, and this is at page 161 of the August 7th, 2002 motion to eliminate hearing, the prosecutor started out in discussing the prior convictions at saying, well, there's this B&E nighttime, and she's focusing on that. Then the defense starts saying, well, no, that involved a knife because in the ABDW in there. And then the prosecutor reminds the judge that she's going to be asking for a charge, a jury charge, on the uncharged predicate felony. There's no indictment for any sex crime in this case. It's just an uncharged predicate felony. So throughout the trial, the defense counsel is arguing that the judge should not instruct on felony murder. He ends up instructing on it, and the jury doesn't find on that theory.
Haven't we already dealt with this kind of political suicide argument or suicide argument? I'm looking at a case called Commonwealth versus DeBerry. You familiar with that?
I read it yesterday, but
Well, we said that
You're like all of us.
the judge did in that case what the judge did in this case, and it was argued to us that the defendant was denied his constitutional right to testify in his own defense. And we characterized the argument as unpersuasive and wrong. Then we went on to say he has a right to testify, but he doesn't have the right to testify free of the effects of impeachment by prior conviction.
Right.
This was decided two years ago.
Right.
So should we
And
change all of that?
And to paraphrase the Rhode Island Supreme Court, criminal trials are full of tough choices.
Well, that resolves the constitutional question about whether this unduly infringed on the right to testify. But it certainly doesn't resolve the other question, which is abuse of discretion.
Right. But
Well, we got other cases that resolve that.
and that say, where the judge has clearly said, I'm exercising my discretion. But again, the defendant didn't testify, and he didn't move for a new trial. Had he moved for a new trial, I'm sure the prosecutor would have dusted off her outline of her cross of the defendant and had at him with the evidence that she had of the telephone records and gone frame by frame through the videotape of the gas station and asked him why was he calling Wayne Freeman so many times on the evening of July 17th, and, where was he going, driving around Hooks, New Hampshire alone? Well, we don't know that he was alone, but where was he going making these phone calls around New Hampshire? And she would have had at him. The defendant was between a rock and a hard place based on circumstantial evidence. The rock was that he claimed to police he left Malden at 5:45, but the videotape put him there at about just after 6 o'clock, and an eyewitness put him there a little while after that, and the fire protection experts, the Commonwealth's experts, put the fire being started sometime between about 6:09 and 6:13, which gave the defendant enough time to set the fire and make it to New Hampshire by sometime around 7. But then again, the defendant is driving around New Hampshire, and he calls the Busseris at 7:18 and again at 8:30. Why is he calling the Busseris if he's at their house? It's because he's out someplace driving around. And so...
Well, he could have called to say, I'm about to get there. People do that. But I think that it hurts the defendant if the defendant is shown to have left Massachusetts later, because it gives the defendant more time to get to set the fire.
Right.
So it hurts him no matter which way that evidence comes in.
Right, which is why he didn't want to take the stand. That's why he didn't want to take the stand, because...
Well, you can't conclude why he didn't want to take the stand. He may not have wanted to take the stand for any number of reasons.
But we certainly can't conclude, as Chief Justice Armstrong said in Preston, we certainly can't conclude that the reason he didn't take the stand is because he was upset about the prior convictions. As I read the record, He's much more, in the 3 weeks that intervened between the ruling on the motion in limine and his decision not to take the stand, he'd seen all this circumstantial evidence come in. He'd seen Ms. Lynch cross-examining and doing direct examinations of witnesses. That's the reason he didn't want to take the stand, not the prior convictions. And so absent a motion for new trial and having it fleshed out before the trial judge with cross-examination of the defendant about why he didn't take the stand, his ticket to review by this court on the issue of the prior convictions is to subject himself to cross-examination by Ms. Lynch.
You know, that's really speculation on why he didn't want to take the stand. I mean, we'll never know. He might, 3 weeks into the trial, he might have been saying, my God, the only way I can have a fighting chance at this is to take the stand. But, geez, I'm going to get killed with these convictions.
I have to say,
But that sort of leads back to the waiver issue, because he didn't renew the argument, because if he renewed it and said, this is why I'm not taking the stand, if he'd filed a motion for new trial saying, I was chilled by my convictions, we'd have a record that the court could rule on this, which is why the United States Supreme Court said it
I think the best, personally, the best argument you've got is that we've got this big mass of case law that says if a judge exercises his discretion, even if the crimes are similar, that's pretty much that. So for the defense to win here, we've got to move that huge boulder, and that boulder has been reaffirmed, you know, as recently as a year or two ago. So we're not in the business of doing that usually, particularly in a case like this.
Can you tell me if the record tells us the distance between where the body was found and where the defendant was in New Hampshire?
There's testimony that the GE plant near where the victim's body was found is about 7 miles from the Busseri's house. There are charts in the record that are maps, but they're big, and so there's photocopies in the supplemental record appendix that are either
double page.
Well, they're sort of portions of the big charts, or they're shrunk, but so they're hard to read. But it might be helpful. You get some sense of the scale from looking at the map. But it's about 7 miles is the answer. In any event, I'd like to move on to the blue fiber issue. The way this evidence came in, I'd like to discuss a little bit the discussion. It's volume 12, pages 247 to 248. And defense counsel discussed this but left out a few key points. Defense counsel pointed out that, you know, this is the first thing I see about a blue fiber. He said this at sidebar to the judge. But he never asked Lieutenant Conley, does it say anything in these 5 3-inch thick binders worth of discovery? Does it say anything there about a blue fiber? He never asked Lieutenant Conley that question.
He was more concerned about the chemist's notes.
Right, which were produced in discovery subsequent to when Intanti left the Cambridge jail.
He wanted to know if those notes said anything about a blue fiber.
Correct. And so what happens is the defense is now saying, well, the only way Intanti could have known something about a blue fiber is if someone else on the prosecution team
No, someone else.
Well, someone else.
Yeah.
Not necessarily on the prosecution team.
Right. But as the prosecutor pointed out, what the prosecutor said was, except if Mr. Crouse was guilty and he knew something about a blue fiber. In other words, defense counsel wants to go there and say, well, there's nothing in this discovery about the fibers being blue. Well, that's just another piece of information that the defendant knew that wasn't in the discovery, including just like the information that the victim had ties to New Hampshire and loved going to New Hampshire.
Weren't the prosecutor and defense lawyer sort of all surprised by this? Weren't they sort of in disarray when this little piece of information came out? Or am I wrong on that?
You're wrong on that, but all the reasons why you're wrong aren't exactly in the record.
Okay.
We don't have in the record the police report that was produced in discovery to the defense about Intanti's statements about the fact that the defendant was upset about the blue fiber. We also
just say that again, because we know that I know from somewhere that he was upset about the blue fiber.
He was upset about the blue fiber. He testified on direct, and I think it was brought out even more on cross that the defendant was very upset about the blue fiber.
No,
That
I was
produced in
talking to
discovery.
the testimony that possibly the business about the fiber didn't come out until April 26th, after Tanti, whatever his name is, had left the jail.
I think defense counsel's point was that the blueness of the fiber
Right.
didn't come out.
But wasn't he surprised a little bit at that point? No? No? Apparently not.
I think he's feigning surprise. There
Oh,
was-
Wait,
feigning it.
wait a
Are
minute.
you saying-
Who's feigning surprise?
Well, I'm trying to figure out how to say this without referring to things outside the record.
Well-
There was discovery produced
Mm-hmm.
to the defense about Intanti's statements. We don't have them in the record. We don't know if that police report says clearly he talked about a blue fiber. Lieutenant Conley was called to testify to the fact that he read through these 5 3-inch thick binders worth of discovery that had been provided to the defense up till the time Intanti left the Cambridge jail, and it took him, a state police lieutenant, something like 40 hours to read through them. So that made it less likely that Intanti had gone through the defendant's cell and pieced together this information from that source. But in any event, defense counsel, when questioned by the judge, said, when the prosecutor said, I don't think there's any evidence whatsoever that I was providing anything to Intanti, the judge said, and this is something defense counsel omitted, how much more do you have on this? Nothing. The judge says, it's perplexing, but I don't know where you can go with it. In other words, absent something tying together this claim that Intanti has some information from somewhere, when it could be from the defendant who knew the fibers were blue, who knew the carpet in the function room was blue from the photographs, who knew there were all kinds of other sources, including the victim's blue jeans, and in any event, this was the fiber found on the shovel where there was someone else's print on it, and it had been there all winter long, and denim is a common fabric, so it doesn't really matter. But in any event, where the judge said it's perplexing, I don't know where you can go with it, it really becomes a lot like the O'Loughlin case, where there's the information about the notes found in the victim's home, and the defense is trying to say, oh, this must be from her ex-husband. Well, unless you come up with something more to link it to that, and defense counsel admits himself it's perplexing, and the judge says you've got some lacunae here, some holes, you've got to tie it up, it's really a relevance determination, and that's broad discretion for the judge to decide relevance. I would ask the court to deny the defendant 33E review and affirm the convictions for the first-degree murder of 14-year-old Kelly Hancock.
Thank
Thank
you,
you.
Ms. Glenn.